Hello, my name's David Winch. I'm a forensic accountant with Bartfield's Forensic Accountants. And today we are going to be looking at variations to increase the benefit figure. Obviously, those variations are done at the application of the prosecution and not the defense. It's a little bit of a difficult topic, as we'll see. It's a little bit technically complex. And in practice, I have not ever, I don't think, seen it done, but it's the first time for everything. So let's crack on. What's the agenda? I'm going to talk about the common thread in these applications, and what that means will become clear, I hope, in a moment. Then the three situations dealt with by sections 21, 19, and 20. And again, it looks a bit strange, but it's easier to deal with section 21 first, and then sections 19 and 20 follow from that, and they're pretty straightforward once you've got 21 under your belt. So we'll look at section 21 in detail, and then we'll look at the similarities with sections 19 and 20. Mention appeals fairly briefly, and then just round up how Bartfield's Forensic Accountants can help you. Okay, so common thread. The common thread here is that there is evidence which was not available to the prosecutor at the relevant time regarding the defendant's benefit. So what the court is going to do is to reconsider the defendant's benefit. And if appropriate, it will then go on to use the machinery of section 6, the normal machinery that it uses in making a confiscation order, with some necessary modifications to make a new confiscation order. And that brings with it an examination of the defendant's current available amount. So what we're going to do, and this is where it gets a little bit complicated, what we're going to do is to reconsider the defendant's benefit at the time the confiscation order was made, or at the time the court decided not to make a confiscation order, but in the light of this new evidence, which was not available to the prosecutor at that time. And then, having worked out his benefit then, we're going to look at his available amount now and work out a recoverable amount, which is the lower of his benefit then and his available amount now. And then we're going to compare that recoverable amount with the existing order, if there was one. Okay, so that's the thread. The situation dealt with then by section 21 is that the court has previously made a confiscation order specifying the defendant's benefit and, of course, the amount required to be paid under the order. But the confiscation order is to be remade in the light of this new information concerning the defendant's benefit and concerning the benefit which had been obtained by the defendant at the time the confiscation order was initially made. So we've now got new information, perhaps a new bank account has come to light, or perhaps he's had Bitcoin that we didn't know about. That information should have been dealt with at the time in the original confiscation proceedings, but it wasn't known to the prosecutor at that time. He's now found out about it, and he wants to go back and recalculate the defendant's benefit at the time the confiscation order was made. So how does that differ from the situation dealt with by section 19? Well, section 19 deals with the situation where the court has not previously considered making a confiscation order, or has considered it and decided not to proceed to confiscation. But the court may now consider making a confiscation order in the light of new information concerning the benefit which had been obtained by the defendant at the date of conviction, or if later, when the court actually decided not to proceed to confiscation. Now, of course, if we're in this situation, no confiscation order has yet been made. So that's how it differs from the situation in section 21, where a confiscation order was made, but we're now remaking it. And the situation dealt with by section 20 is where the court did consider confiscation and actually concluded that the defendant's benefit was nil. And so because the defendant's benefit was nil, it didn't make a confiscation order at all. Contrast that with the position where we say the available amount is nil, where it makes a confiscation order with a benefit figure and a nominal available amount of £1 or £10 or something. Now, in this case, the court has looked at the defendant's benefit and concluded he had no benefit. But now the court is going to reconsider the position regarding the defendant's benefit in the light of this new information, which the prosecutor didn't have available to him at the time of that earlier decision. So as you can see, sections 19 and 20 deal with two slightly different circumstances in which no confiscation order was made, either because it wasn't addressed or it was addressed and there was found to be no benefit. And then we have new information about benefit. Section 21, in contrast, deals with the position where a confiscation order was made, but we now know that he's got, or we have information that suggests that he's got more benefit, had more benefit at the time the confiscation order was made than we were aware of. Okay, so what's the procedure under these sections? Well, in each case, the procedure is very similar to when a court makes a confiscation order in the first place. So the court can make an order under section 18, requiring the defendant to provide information. The prosecutor is then required to make a section 16 statement, and the defendant responds under section 17. So this is just the absolutely standard situation, if you like, that we deal with when a confiscation order is going to be made by the court. That same procedure is applied by section 26. It's not on the notes, but section 26 of POCA actually sets out that when we're acting under section 21 or 19 or 20, we use those sections 16 to 18 powers to have statements of information and so on. And let's just be clear what these applications are not. We need to distinguish these applications, which are about a revision of benefit, from applications under section 22 and 23, where the court is reconsidering the defendant's available amount and not his benefit. And of course, applications under section 22 and section 23 generally are dealing with events that have occurred after the confiscation order has been made. Whereas here, what we're dealing with is information about things that occurred before the confiscation order was made, or before the decision was made not to make a confiscation order, but the prosecutor was not aware of these additional facts at that time. And of course, these are not appeals. Appeals, obviously, where the Crown Court is believed to have made some sort of error, either of law or of its treatment of the evidence presented to it, and an appeal goes to the Court of Appeal. That's a different scenario from this, where we are making or remaking the confiscation order in the Crown Court. So let's look at section 21 in detail. First of all, the requirements. The requirements for section 21, a confiscation order has been made, and there is evidence, and this is the common thread, isn't it? There is evidence which was not available to the prosecutor at the relevant time when the defendant's benefit was last calculated. The prosecutor believes that the court will find his benefit exceeds the relevant amount, and the relevant amount here is the latest amount found to be the defendant's benefit, but uplifted for changes in the value of money. So the prosecutor makes an application to the court and there's a time limit. The time limit here is 6 years, starting with the date of the conviction of the defendant for the offence or offences concerned. And you'll remember this phrase, the offence concerned, the offences concerned, refers to the offences which trigger the court's power to make a confiscation order. So we're talking about a conviction in the Crown Court generally, or a referral to the Crown Court from the magistrates where the conviction has been in the magistrates' court, but confiscation is to be pursued and that has to be in the Crown Court. So 6 years from the date of conviction. Note it's not 6 years from the date of sentence. The sentence, of course, can be on the day of conviction, it can be weeks or months later. And it's the date of conviction that the 6-year time limit for section 21 and for sections 19 and 20 runs. Again, contrast that with section 22, where of course we know there is no statutory time limit on a section 22 application to reconsider the available amount. So what does happen then under section 21? Well, the court is going to make a new calculation of the defendant's benefit. And when making that new calculation of benefit, the court very largely places itself back in time to the day on which the court originally decided the amount of the defendant's benefit. Now, I don't want to keep having to say the time when the court originally decided the amount of the defendant's benefit. So let's call it B day, B for benefit. So we're going to say the court is looking now at the situation as it was on that day, but with the addition of further information. Now, there is a slight caveat to that, which we will come to. But the advantage of the court now has the advantage of the new information, which the prosecutor did not have before. So in the new calculation of benefit, the court will take account of conduct occurring up to that day, up to B day. Not up to today, not up to now, but up to that day when it previously made its decision about the defendant's benefit. And it will take account of property obtained up to that day. It can take account of property obtained after that day only if it was obtained as a result of or in connection with conduct that occurred before that day. So we can think of, for example, with a mortgage fraud, the benefit is based on the value, on the increase in value of the property, isn't it? So in a section 21 reconsideration, we might be saying, right, well, actually, the original decision was made 5 years ago. Since that time, the value of the house, the defendant still got it. The value of the house is increased by another £100,000. Half the purchase price was provided by the fraudulent mortgage. So there's an extra £50,000 of benefit, which we now consider, which we now bring into account. So that's the situation in which we are taking account of property obtained after that day, but it was obtained as a result of or in connection with conduct which occurred before. So if our defendant was subject to confiscation 5 years ago, and since then has committed further offences from which he's obtained further benefit, that doesn't come in to this section 21 reconsideration. In making the new calculation, the court will, if it's a criminal lifestyle case, it will apply the section 10 assumptions. And we know that the section 10 assumptions usually apply up to the date that the court makes its decision when we're operating under section 6, when we've got a straightforward standard confiscation. But here in a section 21 situation, the first and second assumptions, which are transfers received, which is usually the big one, isn't it? transfers received by the defendant, and property held after the date of conviction do not apply to property first held after benefit day. Okay? So instead of those assumptions applying right up to date, they stop at the date the court made its previous decision about the confiscation order. And similarly, the third assumption, expenditure, does not apply to expenditure which was incurred after benefit day. So again, that assumption ceases to operate when the court made its previous confiscation order. And the fourth assumption, which is that property is owned free of other interests in it, does not apply to property first obtained after that benefit day. So you can see how we're setting ourselves back in time to the date when the confiscation order was made, and we're remaking it as if we're remaking it then, but with the advantage of this additional information which the prosecutor didn't have at that time. And the court now, at the same time, goes on to make a new calculation of the defendant's available amount. But for this purpose, the court considers the defendant's current available amount, his available amount today, not the available amount he did have at the time the confiscation order was made. Now, you can imagine that he might have had, for example, money in a bank account at the time the confiscation order was made. That was known about, that was included in his available amount, and which he's now used to pay the original confiscation order. So he doesn't have that money in a bank account anymore. So when we're looking at his current available amount, it might well be less than the available amount he had when the confiscation order was made. So just bear that in mind. In the Section 21 reconsideration, we're considering his available amount now, today. If, having reconsidered the defendant's benefit and recalculated his available amount, the court concludes that it has a new recoverable amount figure, which obviously will be the lower of the defendant's benefit and his available amount, a new recoverable amount figure, and that exceeds the amount ordered to be paid under the original confiscation order, uplifted for changes in the value of money, then if that's the case, the court may vary the confiscation order by substituting for the amount originally required to be paid such amount as it believes is just. So you'll recognize immediately that what we're saying here is that the court has discretion. It has a discretion not to vary the order at all. It has a discretion as to the amount that it orders the defendant to pay. Now that's, of course, in stark contrast to the normal situation where we've got a confiscation order being made where the court basically doesn't have any discretion either about making the confiscation order or about the amount. So under Section 21 reconsideration, the court has the discretion to vary the amount by substituting for the amount originally required to be paid such amount as it believes is just. But that's the case if the new recoverable amount exceeds the amount ordered to be paid under the original confiscation order, uplifted for changes in the value of money. But if it doesn't? Well, if having reconsidered the defendant's benefit and recalculated his available amount, the court concludes that the new recoverable amount does not exceed the amount ordered to be paid under the original confiscation order, uplifted for changes in the value of money, then the court cannot vary the confiscation order. And as I say, that's quite likely to happen because what assets the defendant had first time around, he's perhaps used to pay off the confiscation order that was originally made. And so he may now have fewer assets, he may have a lower recoverable amount than he had back then. And so the court may be in this position where it cannot vary the confiscation order, not because his benefit is less than it thought, but because his available amount is less than it was at the time the original confiscation order is made. That seems a little bit strange, doesn't it, for the court to actually go through and conclude that the benefit figure should have been higher, and then to find that Section 21 does not permit the court to vary the confiscation order. So has this all been a complete waste of time? Well, no, because the new benefit figure should be recorded, as it might be relevant if there's a later application under Section 22. And of course, as we've said, under Section 22, there is no time limit. So if we look at subsection 9 of Section 22, it says the benefit figure is the benefit figure found by the court or any benefit figure found under Section 21. So what we're saying here is, yeah, under Section 21, we find a new benefit figure. We can't vary the confiscation order because the recoverable amount is less, but we will keep a record of that new benefit figure, and that will be relevant to any future application under Section 22. Okay, I hope that makes some sort of sense as far as Section 21 is concerned. Let's just go on briefly to consider the default sentence before we go back and look at sections 19 and 20. So the default sentence, you might think that if we are remaking the confiscation order, and if we are coming up with an amount required to be paid which is different, which is more than it was, then the court would have free rein to reconsider the default sentence and to set a default sentence that makes sense in the context of the new amount required to be paid. That might seem to be a sensible approach, you would think. Unfortunately, that's not the approach that the statute takes. Section 39 applies to the default sentence when an order is varied under Section 21, and that section is quite restrictive. And in particular, in most cases, no amendment can be made to the default sentence. And the reason is that the court may vary the default sentence if, but only if, the effect of the variation of the amount required to be paid is to vary the maximum period applicable in relation to the order under Section 35, subsection 2A. And that's the subsection that gives us these 4 bands of default sentences. But those 4 bands, as we know, are very wide. There is, for example, a band that goes from £10,000 to £500,000. So we might well have somebody who has, say, a confiscation order made against him initially with a benefit of £20,000, and then he's found, let's say, to own another property that the prosecution were not aware of, and all of a sudden his recoverable amount has become £450,000. Well, the default sentence that was set when his benefit was £20,000, when his when his amount required to be paid was £20,000, is likely to be quite low. If we're now saying that the amount he requires to be paid is £450,000, well, you would expect a much heavier default sentence, but the court can't do it. And the reason is that we're still in the same band. So subsection 1B of Section 39 is not satisfied. We're not in a different band. And so the court cannot vary the default sentence when it varies the amount required to be paid. Obviously, if we do cross into a different band, if we go from 20,000 to, let's say, 600,000, then we're in a new band, then the court's got free rein. It can set whatever default sentence it wants within the usual limits for an amount of £600,000. Okay, what about interest and time to pay? Well, the statute actually doesn't expressly deal with interest or time to pay on a confiscation order which has been varied under Section 21. So what seems to happen is that the court just appropriates, if you like, its powers with regard to interest and time to pay to the remaking under Section 21, those powers that it would have had if it was making a confiscation order for the first time. Okay, that's kind of covered Section 21. What about sections 19 and 20? Well, we can deal with them now very quickly. They operate in a similar way to Section 21, but with appropriate modifications to reflect the fact that no previous confiscation order has been made. So again, what you're doing under Section 19, under Section 20, is you're looking at the benefit at the time the decision was first made, or at the date of conviction if no decision was made. You're looking at the benefit up to then, and you're looking at the available amount now. And as we know, there's a time limit of 6 years, up to 6 years from the date of conviction. So we could be doing something like this exercise based on benefit figures 5 years ago. But that's the situation we're in. Appeals. Well, it's fairly straightforward. It appears that either the defendant or the prosecutor can appeal a decision on a Section 21 variation application. The defendant can appeal because a Section 21 variation is within the definition of a sentence in Section 50 of the Criminal Appeal Act of 1968. So defendant can appeal a sentence. And in my view, the prosecutor can appeal because a Section 21 does involve, in my view, the making or the not making of a confiscation order, because Section 21, borrows the machinery of Section 6, borrows the machinery of Section 16 to 18. We are making a confiscation order. We're not varying an existing confiscation order, which might fall outside Section 31 appeals. Also, of course, there's nothing to prevent the prosecutor making a fresh Section 21 application if further new information comes to light subsequently. So long as we're in that time of 6 years from the date of conviction, there could actually be successive Section 21 applications by the prosecutor as more and more information comes to light that he didn't have originally. Would be a bit of a crazy situation, but in law, there is nothing to stop that. And similarly, in my view, a Section 19 or a Section 20 variation may be subject to appeal by either the defendant or the prosecutor, as it involves the making or not making of a confiscation order using the machinery of Section 6, Sections 16 to 18. Okay, a bit of a difficult technical area today, but I hope it has made some sort of sense. I hope I haven't repeated myself too much in trying to get the points across. How can we help? Well, Bartfield's Forensic Accountants is fully staffed. We undertake legal aid work, we undertake privately funded work, criminal, for prosecution and defense, civil, forensic accountancy work as well. And it is relatively easy for us. It has proved to be relatively easy for us over the last 12 months or so to continue to conduct the bulk of our work remotely using our up-to-date secure IT facilities. We are, of course, readily contactable by phone, by email, online, and the website is full of useful information and, of course, accessible 24/7. You can get more on this topic by looking at the blog articles on our website, which are in the news section. And this and previous webinars can be found in the seminars section of the website. In any event, we will send you a free recording of this webinar in the next few days, so you can review it at leisure. If you'd like to get in touch, don't hesitate to email me. The email address is on there. There is also a phone number, I have to say, these sort of queries I would rather deal with by email, because then I've got the facts in front of me, any relevant documents possibly, and I've got a chance to consider carefully what the position is and what the response should be. So I hope that's been helpful. Thank you very much for your time, and we'll see you again in a fortnight. Thank you. Goodbye.